Hello, warm welcome to UCL Laws. I am Denny Manzari. I'm an associate professor in competition law and policy at the faculty and one of the co-editors of Current Legal Problems. It is a great pleasure to host today Professor Mariana Mota Prado, who is Professor of Law, and William Graham Chair, International Law and Development at the University of Toronto in Canada, who's going to speak about redundancy as a legal strategy to fight corruption. Our event today, our lecture, is chaired by Jeff King, professor at UCL Laws, currently on secondment to the Bingham Center for the Rule of Law, where he serves as director of research from 2022 to 2024. So in the CLP tradition, it is the chair that introduces our distinguished speaker this afternoon. So Jeff, the floor is yours. Thank you very much.
Thank you very much, Denny. So it's a great honor to welcome Professor Mariana Mota Prado, who is the William C. Graham Chair in International Law and Development at the University of Toronto, one of the great educational institutions of Canada. She has for many years worked on the intersection between law and development and has contributed and co-written some major books, including Institutional Bypasses, a strategy to promote reforms for development, with Michael Trebilco, who's another great luminary in this area in Canada and in the world, and has co-authored Advanced Introduction to Law and Development also with Professor Trebilco. And so in addition to her experience at this elite institution in Canada, Professor Prado has also done the tour of the elite institutions throughout Latin America, and of course here in London at the Center for Transnational Legal Studies, but also the Getulio Vargas Foundation Law School in Brazil, and ITAM Law School in Mexico, and Los Andes Law School in Colombia, as well as Torquato di Tella in Argentina. So this is a really great centers of intellectual learning throughout Latin America. And so in that time, I think you must have come across many great scholars and much great thinking that will inform your lecture to us today on corruption. And I repeat the title: Redundancy as a Legal Concept to Combat Corruption, Exploring One of the Functions of Institutional Multiplicity. And so, Professor Prado, you have the floor for a good 40 to 45 minutes. And we're very much looking forward to engaging with you here. Thank you.
Thank you. Thank you so much. So let me start by thanking the editors of Current Legal Problems, especially Professor Manzari, for this invitation. It's truly an honor to be here today. And I would also like to thank Professor King for agreeing to chair the lecture and serve as a commentator. So can we just make sure the slides are up and running? Perfect. So I want to start by providing a bit of background information about how this lecture fits with my broader research agenda. And Professor King already mentioned this book. This is a book where I started to think about how to break down this monolithic conception of the state. We tend to think of the state as providing services as one entity, or performing as certain functions as one entity. And institutional bypasses was my first exercise into thinking why it should be just one entity. Why can't the state have 2 or 3 bureaucratic offices providing the very same service or performing the very same function, and in doing so, providing citizens with an option. They can choose whichever one seems to be doing a better job. From that exercise, I also thought about this in the context of combating corruption. So in a series of papers, I have explored the idea of institutional multiplicity, and here the idea of choice, as you can imagine, doesn't work so well, right? You don't choose who is going to prosecute you for corruption, but the idea of breaking down the monolithic conception of the state is still present here. So in the papers about institutional multiplicity, I have explored this idea that we could have more than one agency performing the functions that we perceived to be essential for to ensure that there is accountability for corruption. So there could be multiple agencies doing the monitoring or the oversight, multiple agencies doing the investigation, and multiple agencies doing the punishment. And the way the research went was, as you know, combating corruption, which is the topic of this lecture today, is a challenging task. This research shows that, let's say the minister called the administrative tribunal to tell them not to sanction somebody. The minister may even have stopped the internal accountability system from functioning earlier on, so that avenue is closed. We can think of multiplicity as keeping other avenues open, right? We can further think that for some reason, the judge has decided to accept a bribe and the civil lawsuit didn't go forward, but we still have avenues available to ensure some level of accountability. We could even add here that the police may have been also instructed by someone in the executive branch to act in a certain way. So this is a little bit what I have been thinking about in the last few years. And I took the opportunity to deliver this lecture to further advance this agenda. The only difference between what I have been doing in the past and what I'm going to try to do today is both the institutional bypasses and my institutional multiplicity papers have been very descriptive. I was trying to come up with concepts that explain things that are already happening. Here, I'm going to turn a bit more normative. Tentatively normative, but a bit more normative. So let me take a step back and just start with the basics. And I truly hope this is not going to be a controversial statement. Corruption is a problem. We do have ample evidence that corruption undermines economic growth, increases inequality, leads to inefficient allocation of resources. And there is very interesting recent research showing that corruption kills. You can think about situations where somebody doesn't get the proper healthcare service because the hospital simply doesn't have the equipment due to embezzlement. But there is also more interesting research about indirect lives losses. For instance, in the case of earthquakes, building collapses are highly associated with high levels of corruption, meaning officials who should be supervising compliance with construction rules and norms have been taking bribes, and the consequences, people will die as a result of it. Also, I want to emphasize that although I do work in development and I'm very concerned about problems in developing countries, corruption is everywhere. It can be found in every single region of the world, in every single country. And as you can see from this map, from the Transparency International Perceptions Index, it varies in degrees, but not in its occurrence, meaning every single country has instances of corruption. The redder ones, the darker ones, are the ones where the perception is that there is higher level of corruption than not. So this led the United Nations to declare that corruption is a concern, and it was included as one of the indicators to measure the evolution of Sustainable Development Goal 16. So we are trying to reduce the proportion of people in businesses paying bribes around the world. So this is now I'm turning to a slightly more controversial, potentially controversial topic, which is corruption a legal problem? And while we can all agree that corruption is a problem, some people have disputed whether the cause of corruption is cultural, and therefore law could not help combat corruption. Here, I want to turn your attention to a great research that has been done by two social scientists who decided to test this empirically. And what they have done is they have used a natural experiment, which is diplomats that work for the United Nations in New York have diplomatic immunity according to international law, right? Therefore, they do not have, or they are not, the laws of the country where they're located are not applicable to them, including parking violations. So these diplomats were measured according to their behavior regarding parking, meaning how often do they park illegally? And once they park illegally, they get a ticket. The question then is whether they would pay that ticket even though they were not obliged to do so. And the results were fascinating. Basically, there is a very high correlation between the behavior of the diplomats and the corruption perceptions index indicator from Transparency International. Diplomats coming from countries with high level of corruption tended to park illegally more often and tend to pay the fines less often. Okay, now this research got a lot of attention. Why? Because now people were saying culture matters. It's important. It's clearly that some societies are more prone to disobey laws and engage in corruption than others. And I'm not disputing that by far, no. But very few people have made the following inference: because culture matters, law doesn't matter. And I think that's where I want to call your attention to the fact that that is not an implication that comes from this research result. So the very same study, these are the authors, Fisman and Miguel, they show that after the research was done in 2002, the authorities in New York started to confiscate the cars that were violating the rules. And the numbers dropped, which shows you that there is a starting point, there is an inclination to comply or not comply with the law, but once you add law into the mix, you can change that inclination, the behavior consequently changes. So law also matters. And this is the starting assumption here. Law can help us fight corruption. The question that I want to address is how? How do we use law to do that? So I want to turn our minds to something that I think is a topic that hasn't been addressed in the literature. When you look at the literature on how to design systems to combat corruption, there is a lot of conversations about efficiency. There is a lot of conversations about cost effectiveness. Normally, these are coming from economists, and then you turn to the lawyers and they're concerned about fairness and legitimacy. But when you look at law reforms around the world, what you see is that most of them are failing. They're not producing results. And my question here is, if we have a lot of failure, why we're not asking how to increase the reliability of the systems? How we're not asking how to reduce the amount of failure that exists in anti-corruption systems? So I want to explore this idea today, but let me make two disclaimers in advance. First, I'm not claiming that law alone will solve the corruption problem. Culture still matters. There is a whole bunch of other things that matters, and I'm not denying that. And I'm also not proposing any kind of silver bullet. I don't think there are silver bullets for corruption. This is a complex problem, and it's a multifaceted one that requires a constellation of strategies that complement each other. So what I'm trying to do is add one little contribution into this mix, okay? And what is that contribution? Redundancy. Redundancy is a concept that we don't hear very often in law and legal circles, but it is used quite often, for instance, in engineering. If you're building a bridge and there are structures that are supposed to support the load of the bridge, redundancy is used to describe the structures that are sitting there that may not to get into action unless the original structure fails to support the load. And what are you trying to ensure? You're trying to ensure that if your original system to support the load of the bridge fails, the bridge will not collapse. So I'm borrowing from this intuition from engineering to say, why can't we think about the very same structure within the context of anti-corruption systems? So when you go to the engineering literature, you will find not a standardized use of the terms multiplicity and redundancy. Some people equate the two, and some people differentiate the two. So I took some liberties here and adopted my own definition. My own definition, as the slide indicates, is that multiplicity is the sheer existence of multiple components in a system. So you can imagine, for instance, that a computer has 2 or 3 sensors. That indicates there is a multiplicity of sensors in that computer. Now, when do you have redundancy? You have redundancy only when those sensors interact in a way that they are trying, you only need one sensor for the computer system to work properly. But if that sensor fails, another one comes into action and secures that the functioning of the system will continue. Okay, that's entirely different, for instance, from a system where you have a multiplicity of sensors, but they are working together to enhance the performance of the computer, right? In that case, you still have multiplicity, but instead of redundancy, those sensors are actually complementing each other. And if one fails, the performance will decline, but you still have some kind of performance going. So I want to differentiate multiplicity, which is the umbrella term, from redundancy, which is one particular way in which multiple components may interact with each other. Okay, so redundancy is a form of multiplicity. So let me just go back a little bit. As I told you in the beginning, I have been thinking about multiplicity quite extensively. This work started in 2016 with a series of articles co-authored with Lindsay Carson, and those were generously funded by the UK Department for International Development. So I'm quite happy to be back here where this inquiry started. And then more recently in the 2020s, with research funded by the Social Sciences and Humanities Research Council of Canada, I have been further exploring this. But as you can see, all these articles are within the Brazilian context. I'm from Brazil, I study Brazil a lot, and Brazil is a great source of inspiration for a lot of my research topics. So what I'm trying to do today is 2 things. I want to go deeper into multiplicity. I want to advance that agenda that I started in 2016, but I also want to go beyond Brazil. I want to try to make some more theoretical claims that might be useful for us to think about the anti-corruption agenda. So in that regard, since 2016, I have been saying repeatedly that multiplicity can perform a number of functions. Redundancy or compensation, which is this idea that if there is a failure, the other component in the system can compensate for it. There can also be competition between the 2 components in the system, collaboration, or some form of complementing. Okay. What I'm going to do today, and I think this is how we can advance the agenda, is now we need to start going deeper in each of these functions and understand how do you design a system where redundancy prevails over competition, right? And what are some of the drawbacks, consequences, and risks that you're taking if you're trying to embed redundancy or competition or collaboration or complementarity in a system. So I'm hoping this is the first step in a long research agenda where I'm going to start to go down each of the forms of multiplicity to explore them in greater depth. And one conceptual clarification, I always used compensation because I really love the alliteration, compensation, collaboration, competition, and complementarity. But compensation led to a lot of confusion in terms of compensation for damages, especially when you're talking to legal audiences. So redundancy was the term of choice to avoid any kind of confusion here. So, not sure if there are grad students in the room, but if there are, you know, this is one of the most important questions you need to ask about your research. So what? Why are we talking about this? And I would like to claim that I have 2 contributions by advancing this research on redundancy. One is a conceptual contribution. People are using, for instance, the word redundancy, coordination, competition, it is out there. People who are talking about anti-corruption systems are using these words, but there is no systematization or any kind of harmonization about what we're talking about. So I do believe that by clarifying that multiplicity is the existence of multiple systems, and that multiplicity can perform different functions, I think we go a long way in order to sort of organize some of this literature in a more systematic fashion. But the second, and perhaps the more relevant contribution here, is I think there are some very important policy implications, not in the sense that I'm going to give you policy proposals today, but instead, I think there is some policy questions that have been addressed by the anti-corruption literature that have either entirely ignored the idea of redundancy and could potentially benefit from asking whether it's present or could be incorporated in the system, and also a discussion about systems in which there has been multiplicity, but I think the clarity of these concepts have not been present, and therefore we haven't analytically separated them so clear. And once we can do that more carefully with research, I think the policy advice that we might be giving to countries and policymakers may change slightly, and I will show you how. So 3 of the policy implications that I would like to talk about today are the following. First, it pertains to legal norms. And here the debate that I'm engaging with is a debate about should we use criminal law to combat corruption or should we use civil law to combat corruption? I'm going to tell you in a moment that redundancy may tell you you don't need an either or question here. Law enforcement institutions is another big debate, and here the debate is about anti-corruption agencies. Every single country should adopt some form of anti-corruption agency, empower them, give them resources, and combat research that way. Again, here my question is just one? Why not 2 or 3? So we perhaps can start thinking about that. And then transnational corruption, as you know, extraterritorial legislation has been on the rise for the last decade or so, thanks to a series of international treaties related to this. And my question here is whether the concept of redundancy, both legal and institutional, may help us, again, illuminate some of the issues in this arena. So before I start talking about each of these 3 areas, which is going to be what I will do for the remainder of the talk, I just want to take a step back and say that everything I'm doing is building from the trailblazing work of Susan Rose Ackerman. Susan was the scholar who, in 1975, absolutely changed the way we conceive of corruption, in terms of thinking about it as a result of incentives and systems of incentives rather than a problem that backwards uncivilized societies have. And once she has designed this framework to think about corruption as a system of incentives, she went further to analyze a series of mechanisms that could be used both ex ante, so increasing transparency, for instance, increases the cost of hiding corruption and therefore may discourage someone from engaging in it, and also ex post mechanisms. So penalties and sanctions go a long way in reducing the rewards of corruption and may discourage someone from engaging in it. So I'm squarely within Susan's territory here in everything I'm going to say from now. So let me start with the policy implications regarding legal norms. So this is more or less how the debate goes. Some people say criminal liability is the best because it imposes the most severe sanctions, and severe sanctions is an important part of increasing the cost of corruption. So you can think about, if you think about it in terms of incentives, a bureaucrat may be accepting a $100 bribe to issue a permit. If they're going to be sanctioned for $20, they will need to pay a $20 fine. They might just do the calculation and say, yeah, I can still walk home with $80, so I'll do it. So severity of the sanction is important. Now, other people will say, but the procedures in criminal trials, the burden of proof, the beyond a reasonable doubt standard of proof in common law countries is too high. So the frequency at which you're punished and the likelihood of punishment is lower in criminal law. So we should resort to civil law because that increases the probability that you're going to be punished. And this is also another concern for the people who analyze corruption in terms of incentives, right? If the probability, if the sanction for this bureaucrat who accepted a $100 bribe is $200, but the probability of being sanctioned is zero, the effectiveness of that sanction is null, right? So both of these contributors to this debate are hitting on two concerns that are extremely relevant. But as I said, I think there is a lot in this debate that begs the question of why do we need to choose? And I want to invite you to think of civil, criminal, and administrative liability as systems, okay? And I'm taking a step back here to call attention to the fact that Tina Soredi, another prominent scholar in anti-corruption law and policy, people have framed the anti-corruption system as a system from the point of view of combining the ex-ante mechanisms with the ex post, meaning if you're going to put transparency, you still need criminal law as a backbone at the other end, right? So you put transparency and you put monitoring, but you put the sanction on the other end. That's a system. Well, my question is, why can't we think about the sanctioning system as also a system? Administrative law, civil law, and criminal law should all be a system. Well, you might say, what do you mean? Because as legal scholars, we tend to think as criminal law as performing one function and civil law as performing an entirely different function and administrative law performing a third function. And I am indeed taking a more functionalist approach here, but to my surprise, during the research for this talk, I found out that I'm not alone here. And I need to thank a brilliant RA who has worked with me on this, Gordon Mild, who is graduating from U of T this year, for finding this 2023 report. The United Nations Office on Drugs and Crime has explored not only the possibility of using civil and administrative liability for corruption, but they seem to be thinking very much along the same lines that I am. So let me just tell you a little bit of what they have said. Basically, they're saying that states are increasingly relying on civil and administrative penalties, and they're using the word combining them to fight corruption. So what I hear here embedded in this report is this idea of system. We need to punish people, and this administrative, civil, and criminal mechanisms of punishing people could be working together as a system. So this report is fascinating because it walks you through in detail all kinds of private or civil lawsuits that can be brought. This is just a quick sample of them. So you can have tort actions. And if the criminal sanction is not high enough, you can think about punitive damages within the tort context. You can think about canceling contracts that have been done under corruption arrangements, the recovery of stolen assets and or unjust enrichment could be yet another form of sanction. And also debarment in public procurement processes stands here as another item on the list. So you can see that collectively, if we're thinking about corruption in terms of incentives, especially monetary incentives, these can add up quite quickly if the criminal system doesn't deliver properly. And the report of the United Nations does talk about that. So they say civil remedies may be employed when it's difficult to obtain a conviction due to the death or flight of the defendant, as well as the case of acquittal. Okay, Now, the report also mixes that with something entirely different here, which is the idea that, for instance, some countries can't resort to criminal law and should use civil law or administrative law as a replacement. I'm not interested in the second idea. I really want to explore how we can leverage this combination of these instruments in order to think of them as a system. So concretely, what am I talking about? Well, I'm creating this term called legal redundancy here to refer to redundancy at the level of legal norms. And I'm proposing that we start to think about replicating mechanisms within different spheres of legal action. So one example would be for forfeiture. Some countries have conviction-based ones, so you can only do forfeiture after the criminal lawsuit. Others don't. And I'm saying, do we have to pick and choose? Can't we have both? And we have a system where if it didn't happen in the criminal trial, there is still another avenue to consider. Debarment, same thing. There is a very healthy discussion about whether we should leave the debarment process within the administrative authorities. One concern here being they are within the executive branch and therefore they can be captured. The minister can give a call and say, don't debar this company. Well, and others say it should be the result of a criminal trial. Again, my question is, do we need to pick and choose? Why can't we start thinking of systems where there is debarment, possibility of debarment in both levels, and we see which one may work? Okay, so moving now to the second policy implication, and this is getting away from legal norms and turning to law enforcement institutions. And here, as I said at the beginning, the debate has been dominated by this idea of creating anti-corruption agencies. And the literature has been dominated by descriptions of failures and attempts to explain why they failed, right? So starting from 2005, I think one of the most comprehensive studies about a collection of failures, except for Hong Kong and Singapore, that always stand as the examples of success. You do have a quite wealthy collection of failures. And more recently, this interesting book about Latin America that came out in 2022 also goes around describing lack of resources, lack of independence, lack of powers, lack of governance structures around the agency that allow it to work properly, lack of political will. So the list sort of repeats itself within the literature, but basically the gist of it is these agencies are not. And more specifically, in this particular case, there are some people who are writing that this is a problem. If you have two agencies, that's a problem, right? So these are studies, one in Taiwan. John Hua has done a much larger study about single and multiple agency approaches in Asia and has concluded that multiple agencies approach is always the worst arrangement possible. And this course also shows up in policy circles. So you can see this is one of the OECD reports. The OECD has a mechanism of reviewing countries regularly to map how far they have come in complying with the OECD anti-corruption treaty. And in this report, the OECD criticizes Iceland for having two distinct investigative bodies. Iceland, just as a note, is among the top 20 cleanest countries in the world. So it's quite interesting to me that the report just assumes this is a problem, as opposed to asking whether there is a possibility that actually the fact that they have two agencies and the fact that there is overlap may be helping them combat corruption rather than undermining their ability to do so. And their source here is, we interviewed a few people who seem not to have liked it. And I'm like, well, yeah, the officers don't like to have competition, right? But I don't think that's the source we should be relying on to say whether the system works or not. So I wish I had here an example where I could show you redundancy at work. I do not. The best I can give you is my studies of institutional multiplicity in Brazil, but at the time, we didn't dig deeper into any of the functions. There isn't a careful analysis of redundancy at play here. And Brazil is quite unique because it is a system where not only you have multiple agencies, but they seem to be quite malleable in terms of sometimes cooperating, sometimes competing, sometimes collaborating. And therefore, it would be interesting to look back and see if we can find some redundancy there. But I don't have a concrete example of redundancy in agencies to provide you. I do have, though, one challenge, which is there is a very interesting article that came out in 2021 by Davis, Jorge, and Machado, where they end the article by saying maybe Brazil is a unique case. It might be hard for other countries to be relying on what they call institutional modularity, which is a combination, quite unique combination of multiplicity and malleability, which is what we all seem to agree that exists in Brazil. So maybe that's the case, which I think only reinforces my claim that we should investigate whether we can resort to one of these functions, because maybe countries might not have the modularity that exists in Brazil, but they might have multiplicity that leads to redundancy or some other form of multiplicity that might be beneficial to them. And in lieu of having a concrete example to illustrate this, I have this report from, again, the UN Office on Drugs and Crime from 2003, where they don't have a concrete example, but they outline, I think, the hypothesis that I would like to see explored in the literature. They basically say the vision of fragmentation of law enforcement will reduce efficiency, but incorporate an additional safeguard, which is exactly reliability. We're trying to prevent failure. And they recognize that this kind of multiplicity may generate conflict and confusion. And let me tell you, we have seen a lot of that in Brazil as well. Brazil is not only a happy ending case study. But what they say is if we can manage to find just enough redundancy to make the system fail safe without the conflict, we might be able to improve it. And I think that's the hypothesis that I would love to see explored further in the literature. But as I said, doesn't seem even to be in the agenda. And this is the last item in my policy proposal, or policy implications, which is extraterritorial legislation. And here we're talking about, for those of you who are not entirely familiar with this, countries have increasingly signed treaties to combat transnational bribery. Transnational bribery happens when a company from one country bribes officials in an entirely different country. And the question here is, who should be entitled to prosecute? Of course, if you're dealing with criminal law, it's where the crime occurred, so it would be the country where the bribe took place. And a lot of this legislation is trying to break with that in order to say, for instance, the country where the company is headquartered or based, where they trade stocks, and in some cases, you may have even broader claims of jurisdiction. For instance, if the financial flows went through the financial institutions of that country can claim jurisdiction. But the idea basically is now there are multiple laws that can be applicable to that particular corruption instance, and there are multiple institutions that can come in to try to investigate and enforce. And there is a dimension of this arrangement that is built on collaboration and cooperation. For instance, it is effectively impossible for a country to investigate corruption that happened abroad without the cooperation of the officials, especially police and investigative entities of that country that will help collect evidence, right? So there is a dimension of this arrangement that I agree we will need to resort to cooperation and collaboration. So I'm not denying that, and I think this is partly why this 2023 report invests so much discussion in cooperation. Now, there is also research, Kevin Davis being a leading voice in this, in trying to map when do countries actually decide to cooperate. And Kevin, in this particular paper, discusses the use of game theory to analyze under which conditions countries would be inclined to cooperate or not. So there is a lot of work happening on cooperation and collaboration. What is it that I would like to see in this agenda? Well, I think one, we could try to incorporate what I call legal redundancy, right? So international assistance right now is extremely focused on criminal law. There were a few reports, for instance, that when countries call to say we're doing a civil investigation, the other country would just shut down the communication channels and say we cannot send you documents if you're doing a civil investigation. So we do need to expand this collaboration beyond, with the assumption that countries might be resorting to civil or administrative penalty instead of or in conjunction with the criminal penalties. And there is some interesting research about expanding recognition of foreign law, civil law decisions and foreign administrative law decisions that I think also go a long way in sort of trying to build a system where we have more use of administrative and civil penalties along with the criminal ones. And then I think there is also an interesting conversation that we can have about institutional redundancy. And I think here the idea would be to what extent we can start talking about, for instance, an investigation will be collaborative, but could the prosecutorial and adjudicative and punishing functions be left in a way that if somebody's acting, the other countries don't need to act? And the other countries only come in if the system that was trying to do it fails, right? And I think that's the conversation that I would like to see happening here. So this brings me to the end of this lecture. As I said at the beginning, a lot of my research is about designing things. And here I took a more ambitious tone in order to propose a few things, despite the fact that my research has been about what people have designed, and here's a concept for us to understand what they're trying to do. But I do think that combating corruption requires some creative thinking, requires some alternative arrangements. And I think we need to start adding redundancy and reliability to this agenda. So thank you very much, and I'm looking forward to the discussion.
Thank you very much, Professor Prado, for that terrific lecture. I'd just like to make a few comments before we open the floor here. And I'm not sure, I think the floor is open to our online participants as well. I hope so. So five quick points just to stimulate some further thoughts, which you can answer right away or after we hear from others. The first was about the point that law matters, and I certainly, everything I've seen agrees with that proposition. It's just that the evidence that you gave, that part of your talk, was this illustration that that offending rates on parking tickets in New York was connected to the legal culture from which people had come. So culture matters. But that when the sanction of confiscating the car became into play, then the compliance rate really increased. And so law matters. I wondered whether that wasn't evidence that sanctions matter rather than law matters. We'll come back to this point a bit later. So secondly, it's the concept of redundancy. I can see that this is a concept in play in the field, and I accept that. I'm nevertheless a little perplexed about it because it denotes superfluous, that it's not necessary. And indeed, in this jurisdiction, a redundancy is where someone is laid off, is how we describe it in Canada. Namely, they're not fired, but they're made redundant because there's no longer an economic case for keeping them around. So redundancy seems to imply superfluidity, if I can say that. And you're not, I imagine there was a charge where there were multiple avenues for enforcing anti-bribery laws, that to have a criminal and civil procedures at the same time was redundant. One of them was unnecessary. And it seemed to me that the argument you're developing is that the charge of redundancy is not true because they're not, there's no superfluidity there. They're actually both needed. And so it didn't seem to me, at least, with this first impression, that you were defending redundancy so much as refuting the proposition that these multiple avenues of enforcement entail redundancy. Thirdly, on the distinction between civil and criminal, I couldn't agree more with you. I wonder whether there's a tendency to present civil remedies as being compensatory or restitutive in some way, restitutionary in some way, whereas I think as more of a regulation wonk, I see a function of civil remedies as straightforwardly punitive at times. It's just that they are not offenses in the legislation. And so, and they can entail very important punitive responsibility. And the backbone of criminal law is there. It's necessary there because non-compliance, you use the criminal law to make sure that compliance with the civil regime, reporting, being upfront, paying the fines, is secure. So I can see that at work. It's just that I don't know if the literature tends to distinguish them in this sort of compensatory versus punitive way, but I'd understood civil enforcement as not just compensatory, very much forward-looking at encouraging compliance and punitive in character. Fourthly was about multiplicity. I wondered, and this is just a question, whether you're conceiving of multiplicity in terms of there being more than one institution, rather than different functional approaches, civil versus criminal, because some agencies, it's common for agencies to have both prosecutorial powers as well as the powers to levy civil fines. And these work in tandem. I know in the UK, for instance, they have the prosecutorial functions. In some cases where the fines or the prosecution is serious, they have to notify the Department of Public Prosecution, who can intervene and take over the case as well. So in other words, you have this multiplicity working within institutions as well as between them. And something I'm sure you know about. And lastly, I wondered, and this is in connection with my first comment, whether the severity of the penalty might be, a really important and perhaps more important indication of the policy impact of the regulatory regime, rather than whether or not it's criminal or civil in nature. We might assume that a criminal penalty is always more severe than a civil one. That might not be the case. Impounding a car might be more consequential for a diplomat than prosecuting them for a low-level offense, for instance. And I think for some businesses, it could be, you can see that a multi-billion-pound fine could be worse than a conviction for a regulatory offense. So I wondered whether that severity of the penalty is a really important causation mechanism in the background. Anyway, I put those to you. You're welcome to reply now or to mix your reply in with any questions we have from the floor.
Maybe I'll offer a few quick reactions and then I can complement them, because I imagine some of the reactions from the audience will build on this. And I'm going to do in the inverse order. So severity of penalty. Yeah, it's interesting. The economists have been doing a lot of empirical research on this. And I think you're right in some cases. For instance, in the case of companies, it's at the end of the day, is a matter of what is the number that I need to pay. But especially for individuals, there is potentially a reputational dimension that comes with the stigma attached to a criminal conviction that might play an additional role, even if we're talking about a criminal fine and a civil fine. The criminal conviction per se carries socially an impact that may not exist in the civil penalty. So I think would depend on the actor. I think that would be an answer there.
Okay.
Regarding the multiplicity of institutions or of rules, I think absolutely. I think there is a I'm trying to distinguish, and Brazil has exactly the same arrangement. The prosecutors have civil and criminal instruments at their hands, right? And I'm considering this a form of legal multiplicity,
Right.
even though it's within the same agency.
Yeah.
And I think the dynamic changes quite significantly when you have two different agencies with two different instruments. So a little bit of the research agenda that I'm proposing here is exactly to unpack that.
I see.
Because, for instance, if we're talking about prosecutors that are gonna act in good faith and try to be effective, and they're just lacking the instrument, offering two instruments to that prosecutorial office might be a good solution, right? But if we're dealing with an entirely different problem, which is the prosecutors can be captured by the executive branch or political powers, or they can be bribed, then separate institutions with separate tools may be what we're going to be preferring here. So the arrangement would vary depending on which context we're dealing with, which I think ties to your point about redundancy and being superfluous. I think a lot of what I'm assuming here, as I did with the work on institutional bypasses, is none of these arrangements need to be permanent. So one can think, for instance, about a situation in which you're dealing with such high levels of rampant systemic corruption that investing in the system to create this redundancy is the cost that you need to pay to prevent failure, right? But if the system starts to work and the corruption levels start to go down, then we might be looking at a situation where someone is just not doing anything, right? And then it might be the case that then that second agency may need to be eliminated at that point, which is something that I explored in the institutional bypass as well. So I think there is an interesting cost-benefit analysis, and the economist Susan, in her 1978 book, discusses that quite extensively, which is what is the amount of resources that should be invested in an anti-corruption system? And that depends on the marginal cost of corruption for that society. So I think a little bit of my response here would be the redundancy arrangements would follow that principle in order to say more or less redundancy depends on what is the cost that corruption is generating for that society that requires more or less resources.
Sounds as much like insurance as a redundancy to me, in terms of what you're paying to control for.
Well, I would add two things. Insurance, I think, sounds right, but I think
you may or you may not need it.
yeah, I mean, so yeah, when you think about insurance, you think about what is the level of loss that I might incur if I don't have insurance, right? And what's the probability that I may incur in that loss? So literally, we're talking about, I think, for redundancy would be particularly appealing for countries where the failure is very likely, the system is just not working, and the amount of corruption is so high that the costs to society are becoming paralyzed, right, through all the functioning of every other single system. Then it becomes more and more compelling. So I think I know I left two questions hanging, but
I think one of them was redundant, actually. So we have three questions from the floor. I think I saw, so Chaim, Octavio, and Pedro, thanks. And then Barry Van. Yeah. Okay, got this. You want to
thanks so much. This was wonderful. I wonder if I can pick up on the very last point you were saying about which countries might be more open or in need of redundancy. And I think one of the things that maybe because I'm situated in the tort law literature, there's lots of talk in law and economics about optimal. And you didn't have the kind of optimal redundancy argument until this very last point. And even then, it wasn't in the framing of something that's optimal, but rather who might find this more attractive. So I wonder if you can say a bit more about whether in that normative framework, you can add in the optimal issue, right? So this can go to Jeff's point about having the right kind of sanction. Maybe we don't need multiple different avenues of combating problems. Whereas in countries where we know we have a problem in one place and we can maybe be effective through another agency or mechanism, we can deal with that, but then we have to calculate the cost as well. Sorry.
Was my own job.
Thank you.
as a host.
We have a couple of
And I thank-
microphones. We can leave them up. This is so that our people participating
people-
online can hear us.
Yes. So I'm just gonna repeat the question in case people might
Please, that would
haven't
be
heard. The question is about optimal redundancy, and Haim, it's nice to see you, a graduate from our doctoral program at U of T, who is now a professor here. And the question is, I haven't talked about optimal redundancy, but Haim works in tort law. This idea of optimizing systems is constantly present. So I think my answer is it's certainly something that we need to think about, but can complicate the picture quite significantly, right? And I think you can complicate the picture quite significantly in two ways. If you're talking about optimizing in economic terms, we need to calculate the cost of corruption for society. And that is a huge challenge for economists, right? So while in principle, there is this idea that I just articulated to Professor King about, level of corruption and failure of the system, how do you calculate the cost that level of corruption is causing to society? So I'm going to leave that to the economists who are way more capable to deal with that than I am. From my perspective, which is institutional design, I think the optimal level will get complicated here by the fact that you can do it domestically or transnationally, right? So one question that will come into play that I think we will need to address, and I don't have a good answer to it, is the following. Should a country with very high levels of corruption create two agencies, which is expensive, I grant that, right? Or should they just say, no, we're going to rely on the transnational system because most of our corruption comes from transnational companies, and therefore we don't need to spend our resources on the two agencies because the transnational system can take care of it. And if we can show that the transnational system can indeed help reduce levels of corruption in that particular country, that calculation will become a distributive question, not only a question of cost effectiveness, right? Like, who is allocating the resources that need to be allocated in that system? So I'm sorry I don't have an answer to you, but I think it sparks even more interesting and important questions.
Thank you very much for that. So let's have a couple of questions now from Octavio for us, and then Pedro.
Hi, thank you so much. This is so interesting, and it applies to so many different areas, like the framework, right? We could be talking about environmental harm here, or we could be talking about public health. So any area in which enforcement and compliance are problems, you can use your framework to analyze how we can improve enforcement and compliance through redundancy. So many questions. I'll try to be really quick. I know we're out of time. The resources one. I think it's not only within the corruption issue. So what I've just said, there are so many other areas in which we need to improve enforcement and compliance. So why invest more resources, especially in a context of very limited, scarce resources like developing countries, in redundancy in corruption, but the redundancy in environmental harm or redundancy in public health issues. So you could create so many, you could multiply the institutions endlessly, right? So you need to think about which are the more prioritarious issues, and then the question of whether corruption is one of them becomes relevant, and there are lots of people who doubt that corruption is more important than health or environment. On redundancy, I think I get that when you're talking about redundancy, you're importing it from engineering, so it's not like redundancy in the sense that Jeff was using there, which is something which is unnecessary, but perhaps good to have there if something unnecessary, but rather something which is good to have. So it's like, I don't know, good redundancy or necessary redundancy, and not like something that you can get rid of with no consequences, right? So, but then I have a conceptual question. When you mention civil, administrative, criminal law, I don't see it as a redundancy issue here because they each perform different functions. And so it's not like performing the same function, like and being there, like if one of the other fails. A good example from medical law, which used to be my main area of research, if a doctor makes a mistake during an operation, he can be criminally prosecuted, like if he causes the death of a patient. The patient might want compensation or the family, or he can be administratively punished with losing his license to practice. These are three different sanctions that might be necessary, all of them together, rather than one covering for the other if one fails, and then you come up with the other. And finally, no, that's all. I leave
Thank
time
you,
for
Octavio. So let's hear from Pedro before you answer that question. If you could pass the microphone back, that'd be great.
Thank you so much. I have benefited a lot from your institutional bypasses framework. I work in the international financial regulation, and I think there's a lot of very good examples there, especially in terms of how, fragmentation doesn't always have to be at odds with cooperation, especially if you think that fragmentation is a given. And that's the question of whether bypasses are permanent or not permanent, or whether redundancies are permanent or not, matters less, especially considering international financial regulation. We saw sometimes the regional institutions getting better after the bypasses went away. So the bypasses sort of forced institutions that were stale to move a little bit more. Two questions. I think one very close to what Otavio just mentioned, and on Jeff's comments on redundant or insurance or something of the sorts. I think especially on the multilateral development bank space, we have been using a lot of resilience as a way to indicate something very similar to that. So as a way to mean multiple different agents with different mandates, but that have similar objectives and that can sort of try to collaborate if one of them fails to some instance. And we might be thinking more about how to design systems that are good for resilience, because it wasn't really something most countries or institutions were very worried about. And now with the poly crisis, got to the forefront of the agenda. So maybe redundancy, resilience might be good ways to think about that. And then, yeah, there you go. My other big question, and it might be one of those unfair questions because I think it's your future agenda, but it's something I got asked a ton about as well. So I'll pass the question forwards. It seems a ton of those bypasses, they start as competition. They start because of a certain institutional failure and other institutions or other regulators or other actors trying to get that space. So the question is, how they morph towards something as redundancy, and maybe more importantly, as legal scholars, can we try to drive or design that, help with that, going from competition or harnessing the good aspects of competition in sort of institutional design. One last comment, and I'll promise
Sure.
I'll stop. Not anti-corruption scholar by any means. I did do some work on financial intelligence units. They might have a ton of the traits of modularity that you were mentioning, because we mapped, I think, 150 countries, and every single one had very different compositions of who actually sat on the FIUs. Maybe because they're a newer thing, maybe because they're often created as a result of FATF pressures. But it does look to have quite a bit of what you've been discussing. So yeah, thank you very much.
Okay, thank you for those comments and those questions. We have two more questions to follow after this,
Okay.
and so you can bear that in mind. We can take another 5 to 10 minutes.
5 to 10 minutes.
Yeah.
Okay, so I will unfortunately have to be brief, even though the questions would spark long conversations that I hope we can continue, Otavio and Pedro, later. So Otavio, how to prioritize? Yeah, I'm not getting into that business. I think if a society decides how to prioritize decides to prioritize their anti-corruption system, I'm there to help. I think there should be other governance structures in order to determine how scarce resources are allocated. So I think I'm one level below that in that decision-making process. Now, your question about civil, administrative, and criminal performing different functions, I think dovetails with your original reaction. And I think like a regulatory monk, as you described yourself, I think I'm a little bit of that as well. I tend to see them as penalties in one form or another. And maybe one difference that we might be talking about here is the idea, this is all built on the deterrency hypothesis formulated by Gary Becker in 1968, right? And we do have research questioning to what extent that hypothesis explains how criminal law works. Because we're talking about individuals, we're talking about multifaceted decisions that have a whole bunch of sociological determinants and et cetera, right? So when we're talking about crime broadly defined, or when we're talking about someone who is in a very healthy, high-level status, like a doctor misbehaving, we might be dealing with other determinants of why they might be negligent towards a patient, right? So maybe one distinction I would make is corruption. It's one of the safest areas where this deterrency hypothesis applies. Because why does someone engage in corruption? Because they want more money. You know, there's not much to it at the end of the day. So so when you're dealing with that kind of behavior, then this idea that you may lose your source of income, that's a financial loss. You may have to pay compensation, that's a financial loss. You may have to pay a fine, that's a financial loss. I think that's where the application of the deterrency hypothesis is the most solid. So I would be carefully looking into expanding this to other areas if you're building from the deterrency hypothesis. And Pedro, thank you so much for this. I think there are a few interesting suggestions for me to think about, the resilience being a very good one and the financial intelligence units being another one. I'm going to focus on the question that you have been asked. And I think there is a lot of possibility. So the malleability may not only be embedded in the system, but it may be over time, as you said, right? So one thing that I see, for instance, with the redundancy is you may create redundancy, which is this agency only comes in if the first one fails, but the result might be that the first one sort of sees that accountability and that exposure of its failure as an incentive to pick up their game, right? It might be the entire opposite. They might see that someone is picking up the slack, so I'm going to relax because I don't need to do my job. Someone else is doing it, right? And I think there are some determinants of what is going to be the response that are not going to be amenable to design, because we're dealing with actors who are embedded in social networks, have power, ambitions, et cetera, and et cetera. So there's going to be, I think, some work that doesn't come from engineering or economics that will need to be done from context to context, right? But that being said, I think we can look at the cases where it has happened to see if there is some design we can start off, but like I proposed with the bypasses, right? Everything is a big experiment. We start and try and see if it works.
Thank you very much. So we'll have time for 2 more quick questions. First from Barihan.
Okay, thank you so much. Just 2 very.
I'm not sure the microphone's on.
Okay, 2 very brief questions. So the first one is, I think it's very basic. I'm sure you have an extended account of corruption within which you are working with for your framework. But if your account of corruption, for example, includes some, systemic corruption, which I think political scientists and especially public law scholars recently think about, then, multiplying state institutions may be a good way to think about it. But it may have also some limitations there. If the system, say democracy or constitutional democracy is corrupt in some ways, then there may be still a problem there. So my question is, what is the account of corruption you are working with, for this concept? And I think the second question is related to time. In your analysis, redundancy requires, we have to wait, someone has to wait for some times. A certain institution has to wait. If I got, the metaphor right. And then the question is, what is the time frame within which we are working with, within this conceptual category? And the third question is, what's the role of the people? At the end of the day, I think in many ways the people are the victims of corruption. And what is the role of the people in your framework?
Thank you, Berihan. And then you could introduce yourself for us as well. It should be green.
Oh, there we go. Hi, everyone. I'm Jonathan. I'm a student at City University. Thank you so much for your discussion. It's really interesting, all the things you said, especially how you've brought principles from engineering into the legal and political sphere. I think that's a really sort of like innovative way of doing it. My question's a bit similar to your question. This obviously needs a lot of political messaging. It's going to be quite hard to convince people, the public, that we need to invest in, as you mentioned, sort of superfluous agencies and bodies, which may or may not end up prosecuting or having any sort of success, depending on how the sort of like primary bodies operate and how successful they are. So I guess what kind of messaging do I guess like public bodies, etc., need to have in order to convince people that this is a worthwhile pursuit to undertake? That's my question.
Thank you. Okay, so over to you for final comments.
Okay, and we have 2 minutes, 3 minutes?
2-3 minutes, exactly.
Okay, okay, so I'll be again brief, but especially the question about the conception of corruption that I'm adopting is it's a really important one. So systemic corruption has been extensively analyzed in the literature. I myself have written about it, and the scholars love to talk about it because conceptually is one of the biggest challenges that anti-corruption systems need to confront. If everybody's corrupt, it means that even those making the laws and enforcing the laws will be corrupt. And how do you break that cycle, right? So often the response is the law will not help you here because you can't even get the laws in place or get them enforced. So my response to that kind of skepticism that comes from the systemic corruption literature is builds on a series of works that have shown that this assumption assumes a couple of things. One is that it's impossible to break what they call a stable equilibrium unless you have an external shock to the system. And this has proven to be conceptually not the case. I think Matthew Stevenson at Harvard has a very interesting paper where he breaks it down why, from a theoretical standpoint, that doesn't follow. And building from that, then you start to have people like me and Kevin Davis coming in and saying, so this is how you can do these little incremental changes that over time and cumulatively may start moving that stable equilibrium towards either a different equilibrium or unstable equilibrium, right? So I think that's one response. But the other response is something that I wrote with Raquel Pimenta from FGV, where we talked about where do you really find a society where there is absolutely no person who is not engaged in corruption, right? So when we talk about systemic corruption, more often than not, what we're dealing with is sectors or corruption is systemic as grand corruption, not as petty corruption, or as petty corruption, not grand corruption, et cetera, right? So once you start to look at it in a more fine-grained way, you start to see that there is a lot of room for maneuver in these societies, and I think we need to build more on that. So that would be my response. Time frame, I don't have an answer to that, but I think it's a really important question, especially if you're talking about, for instance, for legal redundancy statutes of limitation. So I think there's something that needs to be thought about more carefully. And regarding the political messaging, absolutely, that's essential. Maybe one initial move is to call it resiliency instead of redundancy. That might take a lot of the stigma out of it. But I think I just want to end on a hopeful note, which is corruption used to be thought as this problem from backward societies that had no solution until the societies became civilized. There was no way of dealing with corruption, right? Until Susan Rosakwan came along and changed that to incentives, and then became part of the international policy circles as a concern and something that needs to be addressed. And now we live in a society where we can all agree that corruption is a problem, right? So if you see these changes of discourses, I think we can pretty much believe that it's possible to change the way people think about things. So maybe redundancy will be thought less as an employment problem and more as an engineering problem, and then we can go from there. So thank you all very much for the questions.
Thank you for that terrific lecture.